It is customary to obtain the informal consent of the parties to the contract and their families prior to marriage. An informal proposal in such meetings is called the Khitbah. Initiating a proposal, while the proposal of another man is pending, is disapproved, but it does not make the final contract of marriage, concluded after such violation, irregular or void. The deciding factor in distinguishing between a regular contract of marriage is that the initial proposal implies a contract in the future, and the marriage contract requires a form that refers to the past. It is permitted to look at the woman prior to the initiation of the informal proposal, even when the man looks at the woman with lust. When a companion of the Prophet, peace be upon him, wished to marry some woman, the Prophet, peace be upon him, said to him, "Go and look at her." The tradition is reported in a number of sound compilations under the heading of Nikkah. The words of the tradition indicate unqualified permission and make it obvious that the purpose is to assess compatibility and inclination between the couple. In this case of necessity, it is even permitted to look at the woman even if it is accompanied by lust. As far as the woman is concerned, there is no restriction on her except that she has to keep her modesty intact. Mere promises, called wad, are generally not acknowledged in Islamic law. In those few cases that they are acknowledged, they render the contract non-binding or terminable, that is, not binding or enforceable. A promise to marry is, therefore, not enforceable, and a suit for breach of promise to marry does not lie. Recovery of gifts or presents exchanged at the prenuptial stage will depend upon the facts of each case and whether such property exchange was by way of a revocable gift. After the conclusion of the actual contract of marriage, the gifts do not become a part of the dower. In fact, a gift made to a wife is irrevocable. In some cases, a stipulation may be made requiring certain payments or the rendering of services in exchange for a promise to marry. For example, a woman may say, "Pay 10,000 to my father and then I will marry you." In such a case, if the marriage takes place, the woman will be entitled to reasonable dower, whether or not the husband has paid the amount to her father. If he has made a gift of the amount to her father, the husband is entitled to revoke the gift. In other words, the customary practice in certain areas of selling daughters is not valid. The authentic narration within the Hanafi school does not permit the stipulation of rendering some service by the future husband. Some later jurists argue on the basis of the case of Moses and Jethro, peace be upon them, when Moses was asked to serve for 8 years. They maintain that this is law for us and valid law of the earlier scriptures. The view in the Hanafi school, however, is that if the husband performs the required service, he is entitled to reasonable wages, whether the marriage takes place or is refused. The conclusion is that a suit for damages for breach of promise to marry will not lie under any circumstances, even when one party has taken some steps, required or otherwise, as a result of the promise.